And good Sunday morning. Welcome to WGN TV Political Report. I'm Paul Lisnick. This weekend, ICE enforcement continues across the Chicago area as the future of President Trump's plans for the city remain uncertain. The White House already appealing a ruling from a federal judge halting the deployment of National Guard soldiers around the city. The temporary pause is set to remain in place until October 23rd. Another hearing will be held to determine whether the temporary order will be extended. In siding with the state and city, Judge April Perry said there was no substantial evidence that a danger of rebellion is brewing in Illinois during Trump's immigration crackdown. Harold Krent is a professor of law at the Kent College of Law at the Illinois Institute of Technology. He wrote the book on presidential powers and joins me this morning to talk about what's next. Professor, good to see you again. Let me start by talking about this 14-day, what's called a TRO, or a temporary restraining order. Why is it 14 days and why must it end? I mean, can it be renewed?
Well, it can be renewed, but usually the temporary restraining order will then merge into a preliminary injunction. Then that's what presumably our leadership in Illinois will want. And once there's a preliminary injunction, then it becomes directly appealable to the Seventh Circuit. What President Trump has done is tried to take a end run around the fact that the temporary restraining order is not appealable by just asking for an emergency, presumably asking for an emergency stay, as they did in Oregon and in California. So this will continue. There may be another hearing before the imposition of preliminary injunction. So if the government takes its cue from Judge Perry, which it may not, it will try to enhance its presentation of evidence before the court. I mean, what the court found is that it was just not credible. It was just too shabby. It was too flimsy of an evidence, and not one to abdicate a rule.
Well, I'm going to pull apart a bit about what you just said there, because there's some things to take further. But first, let me ask you this question. For folks who know about this ruling, if they're walking around the streets today, they say, wait a minute, I still see ICE agents. I'm still seeing stories on television of people being detained or whatever. What Judge Perry's ruling had to do with our National Guard, it had nothing to do with the ICE agents who may continue to do what they do?
Absolutely. The ICE agents have continued doing what they do. And obviously, there's been reports just a couple of days ago of some serious incidents in terms of friction with ICE and their seemingly blunderbuss ways. But her ruling was confined to the National Guard, whether it comes from Illinois or comes from Texas. In either case, the judge held that there was no evidence justifying the president's calling up of the National Guard at this time.
I also want to clarify something else with you, because, and you've indicated this, President Trump has said, look, if the courts don't go my way, I'm going to declare an insurrection. He may do the appeal as well. We'll see how all that plays out. But here's the thing. For non-lawyers watching this, there's sort of two directions, I suppose, a court or a judge could be thinking about. Judge Perry seemed to take the approach, and you've referenced this, of there just isn't insurrection going on here. There's not a revolution going on here. She paid attention to the facts on the ground and the situation on the ground. Now, a court and a judge in Portland has kind of a different approach. They seem to be, at the appellate level, seem to be saying, you know, this is more about presidential authority and presidential power. So I'm sort of curious, from your perspective, you understand presidential powers. Is there a right way to do this? In other words, are judges supposed to ignore the reality on the ground and say, hey, if the president does it, we simply need to defer?
So this is based upon what Congress has delegated to the president. And Congress has delegated two principal situations now, maybe three, in which the president can federalize the National Guard. You know, one is when there is a rebellion, and the second is when there's an inability to enforce federal law on the ground. And so what the court is facing with is, are these conditions set by Congress met? And the president is saying, well, I'm the president. I have all this power in terms of law enforcement. Trust me when I say that the congressional conditions are met. And what judges, I think, should say and are saying is, we will give the president deference, but that's not to roll over and ignore that there might be pretext or there might be simply incorrect evidence presented. So I think what Judge Perry is doing is saying, yes, yes, Mr. President, you have a great deal of responsibility and authority under these statutes, but you have to at least credibly make a determination that we need National Guard forces here, either because there is a rebellion or because federal law cannot be maintained.
And
the
by the way,
president failed to do that.
Sorry, also last week we had a judge who ordered that fence in the Broadview area had to be removed on Friday, by Friday. And my question there is, in those kinds of decisions, where does federal power end and local power begin, right? I mean, I imagine it's different if something is on federal ground as opposed to, say, city ground or something like that. Who makes the call?
Yeah, absolutely. I mean, in terms of the supremacy clause, it's the president that has the authority to protect federal property, federal officers, including ICE officials. And so that it does fall within the realm of presidential authority. But of course, that authority then can't, violate or cut into local policing. And the federal government cannot tell local police how to do their jobs. And so to the extent that any kind of building interrupts traffic flow or takes away some other kind of intrusion into a neighborhood, that's where the local government regains control. So there is an overlap, and sometimes the overlap gets testy, as we see in Broadview, but still, I think there is an ability, should be an ability, the federal government to protect its ICE officials and buildings.
And Professor, just less than a minute left, but I do want to ask you, Judge Sarah Ellis, district judge, also entered a TRO preventing federal officers from using unlawful tactics against peaceful protesters, members of the clergy, and journalists. It seems to be a freedom of speech decision Judge Ellis was using.
No, I agree with you. And, the ICE agents has to proceed with showing the dignity and respect to those in Chicago and elsewhere. And reports are that they're not always doing that, and they're doing it in a way that will try to interrupt free speech from you as a journalist, an important role that you all play during this time period. And so I applaud for that decision.
All right. Professor Hal Grant, thank you so much for being with us. I'm so glad we can count on you. You'll be hearing from us again, I assure you, as this continues. Thank you. Have a good Sunday, and thanks for your time.
Take care.
You too. All right, we're going to take our first break. Up next on WGN-TV Political Report, can Democrats at the State House do more to combat Trump's troop plan? What state lawmakers are adding to their already packed veto session agenda? House Speaker Emanuel Chris Welch joins me next.